what their most recent current actions have been, what they're trying to accomplish before leaving office January 20th. And then looking briefly at what the Biden administration has indicated will be priorities, both for kind of deconstructing what this administration has done, and then also from a more positive policy perspective, what they hope to accomplish in the immigration realm. Again, any questions that you have, please interrupt if you'd like to, or ask on the chat, and I'll discuss those and answer those as we go along. So again, where we've been, where we are now, and where will we be? What's it going to look like moving forward? And then a brief discussion of resources that you can look to understand what really is going on. Sometimes the popular media, regardless of your source, does not provide a comprehensive picture, particularly the impacts on higher education. A quick primer to understand what we're going to be talking about. Since a lot of what we're discussing are changes or potential changes, there's a lot of different ways that the government can make changes. These top three, executive orders, policy guidance, and regulations, can be made unilaterally by the executive branch. So these are directly under the control of the president and the agencies that the president directs. First and foremost, executive orders. We've seen lots of those over the last several administrations, enacting policy through executive order, as opposed to trying to go through a more consistent or durable process. Executive orders can be overturned very easily by the next administration. Policy guidance is something that is done a little bit less formally, and the way that it's pursued is through the agencies themselves. So some have policy manuals that are regularly updated to indicate adjudication standards or the way to interpret certain regulations. We don't always know when policy guidance has been changed, but substantial changes to policy have been implemented in this administration that have had far-reaching impacts. We anticipate many of those things being changed again under a new administration, but the timeline and the ability to do so may be limited. It's dependent on resources and focus on those areas. Regulations are the most formal kind of rule-making or law-making practice that the executive branch can engage in. Most have to follow a formal rule-making process as required by the Administrative Procedure Act, or APA, as you see there. Requires a notice and comment period, requires them to reflect on and adjust the regulation to address those comments, and then a publication period, oftentimes with some delay in implementation. This administration, the Trump administration, has tried to short circuit that of late in particular. We'll discuss that. The courts have prevented them from doing so largely. And then finally, Congress. Ultimately, Congress has the most far-reaching power to make changes to law. Any kind of comprehensive immigration reform, any long-lasting solution for dreamers, that will have to come from Congress. Can't be done by the executive branch. So the stakes as far as immigration policy and major changes are high in the Georgia runoff in January, if we will have all three kind of power bodies in making law in the Democratic Party or not. And that could weigh heavily on whether we'll see any kind of comprehensive immigration reform. And then finally, we've seen under this administration a lot of court involvement. Litigation can have very immediate and long-lasting impacts on implementation of legal standards and changes to law, including very recent examples in the last few weeks. All right, where have we been? This is where we're going to start the hyperspeed. So bear with me. Ask any questions that you have. Pause me on things you want to hear more about. International travel has been a major area of focus. From the very beginning of the Trump administration, the Muslim, as it's popularly called, the Muslim travel ban. Here's the countries you see here that have been exempted. This is still in place. This travel ban is still in place. This is one that is a high priority to be on the chopping block by the Biden administration, to remove this executive order putting in place this travel ban. The current one that's in effect is the third or arguably fourth iteration of the travel ban. Again, the courts got involved early on and found that there was insufficient justification for the identification of these countries, that there was potentially some bias based on religion or other prohibited grounds, and so were prohibited from going into effect. The administration cleaned it up and reissued it once, then reissued it again, and then subsequently updated that reissuance. And now we still have this ban in place. Waivers are available, but only 6% of applicants are granted those waivers. So it's very exceptional to be able to get a waiver. Administrative processing and extreme vetting. This is something put in place by this administration. This is when people are outside the US trying to apply for a visa stamp that would allow them to enter the US. If cases are placed in administrative processing, it's really the black box of the visa process. We have very little insight into what they're looking at. Sometimes it's background check, sometimes it's they're on a terrorist list, sometimes it's just as simple as they need more time to look at the case. But it can delay things by up to 3 to 4, 5, 6 months. With COVID and administrative processing and the closure of consulates, we're seeing cases that have been stuck abroad for 6 to 8 to 9 months at this point. So substantial delays, even before COVID-19, COVID has exacerbated these issues. Also, applicants under the Trump administration are now required to provide social media handles and login information to their social media accounts. So those can be vetted by Department of State officers prior to issuance of the visa. And we've seen a big increase in the amount of administrative processing. Related to that are denials of visas. This is pretty small text here, not going into the nitty-gritty, but you can see from fiscal year 2013 to fiscal year 2018, which was just at the beginning of the Trump administration, and the chart actually provides fiscal year 2019 data as well, and the decrease continued substantially. Actually went down from 533,000 to 462,000 immigrant visas issued, and almost 300,000 decrease from 2018 to 2019. So the bar graph doesn't have that data, but a continuing downward trend on the number of visas issued. Now, the important part here is, and the graph that I don't have up here, is the number of visas denied. So the number of applications has actually remained pretty consistent over this 6-year, 7-year period. So the issuance, well, actually it went up starting in 2013, peaked in 2015, and then has remained about the same since 2015. And the number of issuances has dropped, which means the number of denials has also dropped, has increased. So the Department of State has received instructions from the Trump administration to be very strict in issuing of these visas. Enforcement actions. So this will focus on worksite enforcement, because that's the area that I focus in. But clearly we've seen an increase in enforcement and funding for things like the border wall and other projects under this administration. This data is a little bit dated, but the trends have continued. For fiscal year 2018 as compared to fiscal year 2017. So fiscal year 2017 was the Obama administration, fiscal year 2018 was the Trump administration. Huge jumps, a 300% to 750% increase in each of these numbers year over year. This is not necessarily a problem in and of itself. Frankly, I feel that worksite enforcement is a pretty effective tool to try and ensure compliance with our visa programs in the US. And this is maybe a more effective tool. Other things like a border wall and other ideas may be less effective. That's up for debate. But just an understanding that enforcement has been a major focus of the Trump administration. That trend started with the Obama administration, really. So it's not a uniquely Republican tenet and focus. The Biden administration will likely continue in a focus on enforcement, and appropriately so, but maybe with different methods. Instead of worksite raids, for example, focusing on arrests of the individuals. They may focus on enforcement on the employers. And I-9 audits increasing to confirm that employers are requiring with that requirement. A few things to highlight: F1 students. Over time, we've seen an increasing focus on CPT work authorization. I don't highlight that too much here. That was a major focus in the initial part of the Trump administration, questioning whether CPT was being authorized appropriately by schools. That's work study authorization that can happen during, while the student is studying at the school, like internships and similar programs. Overall, that was really not very successful from the administration's perspective, that challenge. There's been a few high-profile cases of universities that were inappropriately issuing CPT, but for the students themselves, for well-reputed institutions, really not too much of an impact. Under the Trump administration, we have seen a renewed focus on STEM OPT F1 students, indicating and focusing on the requirement for training. They've indicated that site visits can occur, and before COVID had started to occur, by going into employers and wanting to make sure that these employees have the necessary training plan in place, that they continually update that schedule, and that the student is updating their employer in the necessary systems. Another update there was some litigation from outside groups challenging this regulation that allowed for STEM OPT, stating that it's taking American jobs, so it was not and didn't follow the proper process. That litigation was recently shot down by courts. So unsuccessful litigation. STEM OPT is still in place, though enforcement is increasing a little bit. We'll talk about a regulation here in a moment that is currently, we're waiting for it to be released, that relates very closely to this. But where we've been in the past, there was a memo announced in 2018 that was struck down by the court in 2019, changing the rules around unlawful presence. Unlawful presence, what that means is if someone overstays their visa and they have notice from the government, then they accrue unlawful presence. If they accrue over 180 days and they leave the country, they're subject to a 3-year bar. Over a year, then they're subject to a 10-year bar. Students have traditionally not had many issues with unlawful presence because when they enter the country, the document that they're issued says duration of status, or DS. That's what you see at the top of the slide. What that means is that the school has a lot more discretion on when their program starts and ends, and the students are not put on official government notice that they are violating their status, usually for some time. So this memo would change that. Again, it was enjoined, struck down. The administration then pivoted to try and get a regulation in place to accomplish something similar. And we'll discuss that a little bit later because that's one of the recent regulations that we want to discuss. Still going warp speed here. Going to talk about employers and employees. Please interrupt with any questions, concerns, clarifications. So here's some more graphs, again, showing the increased level of scrutiny from this administration, a policy basically by this administration to make things much more difficult for employers and their employees that they want to sponsor. One of the most striking is the RFE issuance rate. So you'll see that this first graph on the left side, this is percent of completions with an RFE. So these are cases that were ultimately approved but received an RFE still. So in 2015, that was at 22%, hovered around there during the Obama administration. Immediately in 2018, and even more in 2019, and we've seen that trend continue in 2020, jumped to 38% and then 48%. So almost half of cases that are ultimately approved, that determine that this person qualifies for the visa that has been filed. Yes, sorry, thank you for the clarification, Lynn and Laura. An RFE is a request for evidence issued by the government asking for additional documentation. So creating a lot of administrative burden for the agency, frankly, when it hasn't made too much of a difference, at least for those cases that were ultimately approved, in the number of cases that have been approved. Now, we have seen a decrease in approvals. So approval percentage of petitions that have received an RFE, 83% in 2015, down to 60%. That's kind of the reverse of the other graph. Approval percentages have dropped from 95% down to about 80%. So still fairly high approval percentage, but when you look at the number of cases, a substantial increase in both the requests for documentation from the government, as well as in an increase in denials issued by the government. One of the hot button issues for the Trump administration from the beginning has been to remove work authorization from spouses of individuals in an H-1B status, which is kind of the primary workhorse of the US business immigration system, that H-1B. Spouses of H-1B holders were able to get work authorization when their spouse had completed the first 2 steps in the green card process. This administration indicated a desire to get rid of this program very early in 2017. But since this was put in place by regulation, not executive order or policy change, they never got around to it, interestingly. It just kept getting pushed back on the administrative agenda. So looks like no plans to get rid of the H-4 EAD. The Biden administration has announced that it intends to retain this program, not to challenge it. There were some major changes and a proposed regulation that would make even more significant changes to the H-1B program. Now, traditionally, the H-1B, as I mentioned, it's the workhorse of the American immigration system. Universities are able to pursue H-1Bs, which are for positions which require a bachelor's degree in a specific field, without limitation. So universities and other affiliated nonprofits are able to get these H-1Bs without limitation. Everyone else has to go through a lottery system. It happens each April or May or March, and there's 85,000 slots. Over the last 5-6 years, there's been consistently at least 200,000 applicants. This last year, there were 275,000 applicants for those 85,000 slots. These changes that happened this last year were largely positive. They created an electronic registration system. Before, employers had to complete full petitions and file them in the first week of April, and then they would send back the full applications for those that weren't selected in the lottery. This electronic registration, if you're selected, you then prepare and submit the full application. So it's much more efficient. It worked quite well. There were some issues, but it worked quite well overall. They also reversed the order of the lottery. What that means practically is that those with US master's degrees, there's 20,000 set aside for those with US master's degrees, had a 15 to 20% higher chance of selection. So instead of around 30%, they were around 45 to 50% chance of selection this last year in the lottery. It also has meant more efficient usage of the 85,000 slots. If a case was denied before, USCIS didn't reuse that number. Whereas this year, for registrations that are selected, if you don't submit an application or that application is denied, USCIS is reusing that and is providing additional filing windows. So overall, this was a positive change under this administration. However, a new proposed regulation could substantially change the way that this lottery system works. Traditionally, it's been a pure lottery, regardless, besides the US master's degree prioritization. Everything else has been irrelevant as far as your likelihood of getting selected. They have proposed to prioritize it by wage level, which again, we'll talk about in a little bit more in a moment. Green card backlogs are not a new problem under this administration. This has been the case for years and years. Those born in India and China in particular are subject to these backlogs. What it means is that green cards are allocated by country and by category. There's specific green card category types, both employment-based and family-based. And those from India and China in the employment-based context in positions, again, that require a bachelor's degree or higher, or even many faculty positions at universities, they have to wait for years and years before they're able to obtain the green card. Some legislation has been proposed to remove the per country limitations, but not increase the number of available green cards. That would just put everyone in a spot where they are waiting for years before they get a green card, not just those from India and China. So remaining to be seen what further steps are taken on this by Congress, really, in this next administration. Refugees and asylees. Now, this is not an area where I primarily practice in. There's a lot of complication here and a lot of recent changes that, frankly, I haven't gotten into in very much depth. So I'm going to give you some high-level details. If you want to really dig into this and understand more, I have some recommendations for you at the end of the presentation for organizations you can get in touch with to see what you can do to assist. Or just to understand further what changes have been made by the administration. But this has been a big area of focus by the Trump administration. So first, a definition. Refugees and asylees have the same legal requirements to get that status. We'll look at it. Let's just skip forward to this slide. So for a refugee or an asylee, you have to be unable or unwilling to return to your home country or to remain in your home country because of persecution or a well-founded fear of persecution on account of these protected grounds: race, religion, nationality, membership in a particular social group, which is pretty broad, or political opinion. So that's the legal definition. It's the same for refugees and asylees. The difference is a refugee is someone who is in a refugee camp outside the US. They're very heavily vetted before they come, and once they're admitted, they can apply for a green card after a year of being here in refugee status. So all the vetting and the confirming that they qualify happens outside the US. An asylee, on the other hand, is someone who comes to the US and asks for asylum. Traditionally, refugees, there's been a limit set by the president. The president actually has the ability to set this ceiling each year. The blue line on this graph is the annual ceiling set by the president. So you can see, in the 80s, at the beginning of this program, very high numbers for obvious reasons related to the Vietnam War and other crises around the world. That dipped down, went back up again in the early 90s, and then since 2000 has remained really consistent. Around 70,000 to 80,000 each year, up to 2017, we saw an increase at the end of the Obama administration, up to 85,000. And then you can see with the Trump administration, that has just plummeted. So an initial allocation down below 60,000, and then most recently at 20,000. And the initial proposal was for 0 by the administration, but they changed that when they ultimately made the announcement. And admissions have similarly dropped. What this means is, however you feel about refugee admissions and our humanitarian approach as a country, it's a huge change. And all done by just the president indicating that he doesn't want to admit this many refugees, and he has the power to do so. That's something that could reverse, likely will reverse very quickly with the Biden administration when they set a new ceiling, probably go back up to this 70,000, 80,000 range. But far-ranging impacts on refugee resettlement organizations, communities that provide services to refugees, nonprofits that provide those services. It's been a very different 4 years for those organizations than the previous 15. The administration has made a lot of changes. Again, I'm not going to go into the details here, but the Attorney General referred a number of cases to himself and tightened the limitations on these groups. Also, very recently, a new regulation was finalized, which decreased the timeline to file for asylum. So after someone enters, they have a year to file. If they don't file within that year, then there's some ramifications. Doesn't mean they can't do it, but they have to go into deportation proceedings in order to file for asylum, rather than being able to file with USCIS. That limitation is now 15 days. So it went from a year to 15 days under this new regulation, which is, I mean, think about someone new coming into the country, number one, making the decision to do it, and number two, finding legal counsel to help them if they want. That's never going to happen in 15 days. Number two, they substantially increased the fees. So before, the understanding was, well, there was a nominal fee. The understanding was that, if you're coming in, you're seeking asylum, you probably don't have a lot of money to pay for an asylum case. Those fees have now quadrupled and could be a substantial burden on these potential asylum applicants. The asylum program has long been an area of controversy. There's a lot of things that have high potential for fraud or for people gaming the system. So it's understandably controversial. Changes are necessary. But making unmeetable expectations is probably not the best way to revise the system. Again, congressional action may be most appropriate in this area. All right, the undocumented. More specifically, DACA. So DACA stands for Deferred Action for Childhood Arrivals. This was designed by the Obama administration to assist those that are popularly called the dreamers, individuals who came into the US as children, who didn't necessarily themselves make the decision to come to the US, who have since met other criteria, including staying out of trouble with the law, getting a high school education, things like that. They are able to apply for work authorization under the Obama era executive order. Now here again, this was not a regulation, this was an executive order by the Obama administration. The Trump administration tried to rescind that executive order with their own executive order, which in many cases is doable and not an issue. Here, because there were specific benefits given to these individuals, in order to remove those benefits, to take those benefits away, additional process had to be followed. This case eventually went up to the Supreme Court. The Supreme Court said that the executive order was not sufficient. It didn't, with enough specificity, define why this was necessary to remove and the process for its removal. And so the Trump administration's executive order was struck down. And the Supreme Court ordered that USCIS re-implement the Obama-era DACA program. Now, it took USCIS about 4 months from the time of the Supreme Court decision to allow for new applications under the DACA program, which was maybe a little shocking. But just very recently, in the last few weeks, they officially announced that they will accept new applications. The Biden administration has indicated that they plan to keep this available moving forward. DACA is not a long-term fix. Most of these individuals, while they can get work authorization and get renewals of that work authorization for a long time, are not able to get permanent, stable status in the US. They can't apply for a green card for most people. There's a few exceptions. Ultimately, any kind of sustainable solution requires congressional action. So this is where Congress has passed a few, or one part of the House or the Senate has passed proposals in the past, but those have never gone anywhere. So remains to be seen what Congress does with those DACA recipients and other undocumented individuals in the US. All right, take a deep breath for a moment. That was a lot, and that was a very quick, brief, non-comprehensive overview of the changes that have happened under this administration. Lynn and Laura can attest to a lot more detail as to the impact on them and students, but at least gives you kind of a sense of where we've been for the last 4 years. I want to take a moment to talk about the last 2 months and the next month before January 20th and the change of the new administration, because there are some very high profile and high stakes changes that could happen before January 20th that could make it difficult for the Biden administration to quickly rescind those changes. Any questions before I jump into that? All right, you asked for it. Let's do it. Okay, new regulations. There are 4 of these new regulations that I want to highlight. Again, another one was the asylum regulation that already went into effect. That's very high stakes for individuals in that scenario. These all are directly related to business immigration and to students and their future prospects in the US and current prospects in the US for pursuing studies. So first, from the Department of Labor, a prevailing wage interim final rule. That's important. That language is specific, interim final rule. A proposal by the Department of Homeland Security to tighten the H-1B program, also an interim final rule. Department of Homeland Security's proposed regulation. Now this is different from the interim final rule. This is a proposed regulation that went through the notice and comment period. And that notice and comment period has been completed. This would eliminate duration of status. So instead of being admitted for duration of status, they would be admitted for a specific period. And they would have to extend that status by filing with USCIS rather than by action from the school. And then finally, a regulation to change the lottery system for the H-1B program for those that have to go through that lottery system. That notice and comment period actually just barely completed. So we're waiting for final regulations on those 2. Spoiler alert, the first 2 rules in the last week and a half, 2 weeks, have been found invalid by 3 separate district courts because they failed to follow the normal process. They released them as interim final rules on October 6th. One went into effect 2 days later. The other was going to go into effect on December 8th, so 2 months later. No opportunity for notice and comment. Nobody had any idea what was in those until they were released on October 6th and went into effect 2 days later. On those procedural grounds, those regulations have been found invalid. There have been some reports that the administration is trying in the next 30 days to correct that and to do some kind of process and release a final regulation. That's pretty unlikely. But this administration is trying very hard to make things as difficult as possible in all realms of immigration, and here specifically the business immigration realm. All right, quick summaries of these rules. The prevailing wage rule. So for both green card processes and particularly the H-1B process, employers are required to pay what's called the prevailing wage. This is set by the Department of Labor by occupational category. So software developers, for example, or university language teachers. It is also dependent on the level of experience. So wage levels 1 through 4, level 1 being entry level, level 4 being expert, and the specific location. This is all published, publicly available information. And those wage levels are required to be paid by employers. The idea is to avoid prejudicing US citizens. They also have to pay the same wage rate they would pay to similarly situated US workers. So it also protects the foreign workers from being paid less than they should be paid. So labor exploitation. There are some ways to get around this. As I mentioned, litigation recently was successful. If it's appealed, it may be reversed, could go back and forth. But as of right now, this rule is not in effect. It was up through December 7th. So for 2 months, we had these new wages in place. To give you an idea of the substantial nature of these changes, so statistically, these wages use percentiles. So first percentile for the entry-level positions was historically at the 17th percentile for level 1. It was increased to the 45th percentile. Huge jump. For some positions, for example, a software developer in Denver, this meant an increase from around 60,000 to over 100,000 for entry-level positions for a software developer in the Denver metro area, someone coming fresh out of school. And then associated increases. You look at level 4, a jump up to the 95th percentile. Statistically, that's just not tenable. You can't use statistical data from that far end of the curve and hope for it to be reliable. And so even expert positions, that same software developer in the Denver metro area was up over 220,000, which there are not software developers that make over 220,000 in the Denver metro area. So it was really not based in reality. Huge impact, put a lot of things on hold. If it remained in effect, it could have effectively meant that many employers were not able to pursue extensions or new H-1Bs for current or new employees. Strengthening the H-1B rule primarily was focused on those employers that use what's called third-party placements, which has been an area of fraud and concern in the past, so an understandable focus, and change is probably needed in that area. Also tightened up the definition of specialty occupation, making it a little bit more difficult to obtain H-1Bs. Practically speaking, maybe not all that different from the approach this administration has taken. And as I mentioned, the courts. So 3 district courts have found both of these regulations because they used the interim final rule process to be invalidated. That's where we stand right now. The administration may appeal that and they might go back into effect suddenly. But it's anticipated that these will likely not remain the law. As I mentioned, a regulation eliminating duration of status for F students and J exchange visitors, which J exchange visitors are also heavily relied on for positions like postdocs and research positions within universities. This would mean that their I-94s, the document that they're issued when they enter that indicates their status and the duration of their status, instead of saying duration of status or DS, it would be tied to their program end date no more than 4 years at a time. They'd have to apply for an extension, which can be an expensive and long process without a lot of clarity. Some groups are subjected to 2-year admissions. They also reduced the grace period for these students from 60 days to 30 days. It did provide one benefit, which could be useful for employers, allowing students with expiring work authorization who have pursued the H-1B process to have an automatic extension of that work authorization through April. Right now, that's just through September. So that was a positive provision that was included. It would also require students to go through biometrics consistently each time they apply for an extension, which can be a difficult process. And there were some changes to the filing windows for EADs. So pretty substantial change, very strongly opposed by universities. I reviewed a letter, for example, from a major athletic conference that was very specifically explaining the impact it would have on student athletes, because many student athletes go for 5 years because of eligibility rules. So that was just one example, but it was strongly opposed. Many comments were submitted. We are currently waiting for the administration to review those comments and to issue a final regulation. If that happens before January 20th, then it gets complicated because the Biden administration may have to promulgate new regulations in order to get rid of that regulation that was promulgated by the Trump administration. So we're waiting with bated breath to see whether that is published before January 20th. If it's not published before January 20th, then it's probably not going to happen. The Biden administration has already indicated that this is one of the regulations that they intend to rescind if it has been published, though it would take some time to do that. And they could choose just not to pursue it or publish it once they enter the office. Prioritization of H-1B lottery. So this would change from a pure lottery to prioritization by wage levels. So those same wage levels we saw from the Department of Labor, starting with level 4 down to level 1. The main impact here is on students. So many students get work authorization after they graduate for 1 to 3 years. 1 year for non-STEM fields and 3 years for STEM fields. And then they transition to H-1B status by going through this lottery system with those employers that employ them after they graduate. It's been difficult with the number of applicants regardless. Many students ultimately don't get selected in the lottery and have to figure out another solution or return home. This would potentially impact them even more because most positions that students are entering into, understandably, are entry-level positions, level 1 or level 2. The change to the prioritization would require that they issue H-1Bs to those with level 4 wages first, then level 3, level 2, level 1, which could greatly decrease the chances that students have at getting selected in this lottery, which could ultimately reduce the desirability of higher education in the US and the prospects for employment after that higher education. So this has far-reaching impacts. It had a shortened comment period, 30 days instead of 60 days, but it did still have a comment period, which means it's a little bit less subject to litigation challenge. It will certainly be challenged. The number of comments that were submitted for this regulation, however, was much, much lower than for the F1 duration of status, for example. So it's possible that the administration, despite the fast timeline, could publish this regulation. And the concern here is that it's not clear that this is a regulation that the Biden administration would challenge. It makes common sense to prioritize the H-1B according to what people are paid. The problem is that that doesn't take into account the impacts on really a large part of the purpose of the H-1B program, to provide an avenue for students to continue to remain and work in the US in positions that require a bachelor's degree. So here you see a summary. If the rules do come back, those first two from the court decisions, the Biden administration will get rid of them eventually. If the F1J1 regulation is published, the Biden administration intends to rescind it. It's not clear what the Biden administration's plan is in relation to the prioritization of wage level for the H-1B lottery. So that's a big question mark that we're not sure about. This is just a very brief update. We're getting close to the summary of what we intend, or what the Biden administration has announced they intend to do in the immigration world. This is nitty gritty. There was some legislation that was passed. These days, any immigration legislation that's passed by Congress is big news. Congress hasn't passed major immigration legislation for years and years. So USCIS has had a lot of funding issues, arguably many of them caused by policies of this administration to require things like interviews where they weren't previously required, biometrics where they weren't previously required, an increase in requests for evidence. None of those things get the agency additional fees, and USCIS is a fee-funded agency. They don't get congressional monies. They don't get tax dollars. They're paid for by the fees paid by these immigrants paying the fees. So this legislation basically just makes it so people can pay more money to get a decision faster on their case. Increased the fee that was in place for those applications that already were eligible for this program. So went from $1,440 to $2,500, and then indicated that a bunch of other categories would be eligible for premium processing. However, Congress passed the law in October, beginning of October. USCIS has not yet implemented the expansion to the other categories. Arguably in their best interest to do so, because they would get more money from people who wanted a decision faster on their case. Huge delays. Some applications have 17 to 22 month timelines, for example, to get a decision on their case. So huge delays that we're seeing under this administration. Some maybe as a result of COVID-19, but it's anticipated that that's one of the changes we'll see under the Biden administration. some increased efficiency, a focus on customer service, and improved processing times under a new administration. All right, where are we going? We don't have tons of detail. This is a pretty good summary of what we do have. A lot of these things we've talked about. So we can expect a Biden administration to restore a more customer-centric mindset at USCIS, potentially decreasing processing times, making it easier to access officers and get answers on answers to questions on cases. Restoring the DACA program and TPS. TPS is temporary protected status. That actually was recently extended for many countries through October. So that was kind of already done by this administration, but that's expected to continue under the Biden administration. We talked about the H-4 work authorization. That's expected to continue. We talked about which rules would be expected to be rescinded if they went into effect. One major thing that we didn't talk about that has been a subject, again, that we could take the full hour on is what's called the public charge rule. This was a proposed regulation that greatly changed the standard for what's called a public charge determination. What that means is that the government, for anyone that they feel could become a public charge, meaning that they are reliant on government monies, basically, in the future, could be denied a green card. Hasn't been something that's really been used in the past. This administration passed a rule requiring the provision of a whole bunch of personal information, including credit reports, tax documents, information on debts, substantial amount of documentation. And if they have received government benefits, then it creates a presumption that they're not eligible for the green card. This has gone back and forth and back and forth. Currently, it's in effect. There's been, I think, over the last 6 months, maybe 6 times where it's been enjoined by a court, but then on appeal, the injunction is held off, meaning that the rule would remain in effect. It's been this roller coaster. Regardless, the Biden administration has indicated that they intend to rescind that rule, which would greatly reduce the burden on applicants as far as the documentation that's required, and still allow USCIS to make these determinations as they feel is necessary. Travel bans. There's a lot of COVID-19 travel bans right now, for example, an H-1B travel ban, visa ban, the Muslim travel ban we talked about. Likely that the Muslim travel ban definitely will be rescinded by the Biden administration quickly. The other travel bans related to COVID-19 may be more complicated. The H-1B visa ban is scheduled to expire on December 31st. If the Trump administration extends that, then the Biden administration has indicated they intend to get rid of that. But area-specific bans, for example, on the Schengen area, Europe, China, Iran, Brazil, those may not go away until we see an improvement in cases in those countries. The duration of status rule we talked about. Another major change by this administration is they announced that they wanted to gather substantial additional biometric information on any immigrant, including retinal scans, face prints, just all sorts of kind of crazy stuff. Right now they gather fingerprints and photos. But this new rule would collect a substantial amount of additional information. The Biden administration has indicated that they don't intend to pursue that rule. Otherwise, as far as positive changes, it's really not clear. The Biden administration has indicated that they do want to see some changes to the H-1B program. So some of the proposals that we've seen come through may not be that far off from what the Biden administration could pursue. Prioritization of the H-1B lottery may remain in effect, for example. They will likely also remove a lot of the limitations on asylees and refugees, but that's a program that has long come under fire and could be the subject of other changes to try and tighten up and reduce fraud and other things that have been associated with that program. Ultimately, to see comprehensive change is outside the hands of the Biden administration. While they can have a substantial impact, Congress needs to act if we want to get any kind of comprehensive immigration reform and get our system to a place where it has the trust of the American people more broadly. I think there's a broad-based view that has been the subject of a lot of misuse. And I think there's some truth to that in many scenarios. It's probably less far-reaching than many in the public tend to perceive. But there are changes that need to be made and solutions that need to be arrived at. And really, Congress is the only one that has the ability and the power to make the kind of changes that could improve the system for everyone. As a quick summary, if you want to look at additional information about any of the changes that have happened, these are really great professional organizations that I'm affiliated with and work with closely. They publish a lot of information about these changes. NAFSA is particularly good in the higher education context. They're the leader in this area as far as regulatory and other changes. They have a lot of publicly available information. If you're looking at getting involved more locally, here are a few organizations that I work with as well for pro bono work and other things. So these are great organizations for providing assistance to individuals locally. Then ultimately, you could geek out and go look at the government sources if you really care to do that. It's the best source to understand what it really means ultimately, even though it's really hard to understand a lot of times. So don't necessarily rely, if it's something that you're interested in, that you feel passionate about, that you want to see change, or you want to understand what you can do to affect change, don't rely just on what you read in the popular media. Go to some of these other sources. You can reach out to me as well, and I'm happy to give you my thoughts and to point you to sources that you can go to look into it more yourselves. So in that spirit, thank you for allowing me the time today to talk with you. That was a lot of content. My brain is exploding. I'm sure yours is too. And here's my contact information. If you do have questions that you'd like to discuss further with me, I'm happy to discuss.
Oh, thank you, Stephen. That was a lot of information, and I appreciate that you highlighted some of the things that directly affect people here at DU. The H-1B prevailing wage law that was recently thrown out was very problematic, to the point that the chancellor and the provost agreed that DU join one of the lawsuits. Also, the H-1B changes that will affect possibility for future employment for DU international students and those F1 rules. So there was a lot there and a lot that directly impacts people here. If you have any questions, please unmute and ask or put them in the chat. We have a few minutes left. There's a question in the chat, when the new premium processing rule can go into effect.
A good question. So if you're referring to the legislation that was passed by Congress in early October, which is what we talked about, that depends entirely on when USCIS decides to implement it. They've implemented part of it, increasing the fee to $2,500 instead of $1,440 for those that are already eligible for premium processing. As far as opening to other categories, the timeline on that is completely unclear. It could happen today if USCIS decides that they want to implement it. There has been no communications from USCIS giving any kind of indication on when they intend to implement that rule, or sorry, the legislation. Now there is some more complication there with a rule that was going to go into effect in early October that was invalidated by courts. We don't need to go into that, but as far as the legislation and opening to other categories, it's unclear when USCIS intends to implement that.
Anything else? Okay, well, thank you once again, Stephen. We appreciate so much that your willingness to present on campus and keep our community up to date on so many important and complicated issues. Just regarding the duration of status rule, I'm certainly hoping that that doesn't go into effect because we know it will take time to be rescinded. But in the meantime, we're encouraging international students to request extensions. And I hope that they will take advantage of this period when it is still basically under the control of those of us in International Student and Scholar Services. I don't see anything else in the chat, so we will end here. Thank you all for attending, and we'll maybe see you at this time next year and see what has happened by then. Thank you.
Thanks, Laura. Thanks, Lynn.